most of you have met Robert before. Robert's given us a couple of seminar talks. Robert's from Gaydon Lawyers. They're a specialised construction lawyers with close association with the Master Builders Association, including the Legal and Contracts Committee, the Property Council of Australia, and the Institute of Arbitrators and Mediation Australia. Tonight's talk will be of good interest. Hopefully it won't occur to any of us, but it's still nice to know a little bit about it. So please welcome Robert. Thank you.
Thanks, Alan. Thank you for once again permitting to speak to you tonight. I think it's the third occasion I've spoken to the Australian Home Warranty outfit. It's a pleasure to be here once again at a venue that's much closer to my home this time. Being a resident of Hornsby, the old Condell Park was sure a long trip. Now, Alan is hopeful that the subject matter of tonight's talk is something that won't happen to you, and I'm also hopeful of that, but the chances are that you're going to come across it, particularly in this current business environment. And I'll be talking tonight on builder insolvency, and of course that relates to the insolvency of subcontractors as well as builders, and we might even touch a bit upon the insolvency of the principal as well. So I wanted to talk about three main things: the types of insolvency administrations that we see, construction issues and construction contracts is the second thing I want to talk about, and how they're relevant in the or what's relevant in the contracts in the context of an insolvent builder or an insolvent subcontractor, and some possible suggestions or matters that can be adopted into contracts to perhaps better protect both the contractor and the principal. There's four main forms of insolvency administration that, if you aren't already aware of them, the chances are that you'll become aware of it some time through this current cycle, because anybody in business is being faced by these issues. The first is receivership. There's voluntary administration, deed of company arrangement, and liquidation. Now, first of these, receivership, that usually occurs, something that occurs at the behest of secured creditors. I think I can wander around because I'm wired for sound here, aren't I? So I'm not necessarily anchored to the lectern there. So receivership is something that occurs because the contractor has entered into arrangements with its financier to lend it money, and the financier has taken security over the assets of the contractor, and usually that could be by way of a mortgage if it's land security, or it could be by way of a company charge if it's over the assets of the company. Not at all unusual. Usually a bank bank require that type of security if they're going to make any material or substantial advance. The documents that you sign when you're getting that bank loan contain the power for the bank to appoint a receiver in the event of default by the contractor. And when I say default, the most common form of default is failure to pay, failure to make repayments that are scheduled under the contract. Now, a receiver is somebody who's appointed by the bank or financial institution or the lender of the money. And really the sole purpose of the receiver is not to look after all the creditors of the company, it's to look after the interests of the bank. The receiver will be funded by the bank, and the receiver will take over the assets of the company, usually a company, over which it has security. It will liquidate those assets, that means sell those assets, and it'll apply the proceeds of the sale towards, first of all, the costs of the appointment of the receiver, then the receiver's own costs of its activities, and then if there's anything left over, towards the bank debt. If there's any money left over after that, then the receiver will just pay it to the company, back to the company. Chances are that it'll completely stuff the company though, because its best assets will be taken, its best and most liquid assets will be sold and applied, and usually that's going to mean the core of its business is gone. So it's not a good sign if a receiver is appointed to the company. Another form of insolvency administration that doesn't necessarily mean the end of the company is a thing called voluntary administration. And an administrator is appointed by the directors of the company itself. Has anyone heard of administrators being appointed to companies? Yeah, it's a pretty popular insolvency method at the moment. It gives the company a bit of a breathing space. And it's a 21-day breathing space, a bit of a moratorium where the creditors of the company, even secured creditors, can't do much with their security at all, whilst the company tries to work out whether there's any strategy, or the company and the receiver together try to work out whether there's any strategy to, first of all, perhaps maximise the amount of money that's available to pay out the creditors of the company. Or secondly, in a good case, a strategy to enable the company to trade on, particularly if the company is worth trading. It might be a good company. It might just have a cash flow problem that with proper administration and proper arrangement and understanding from the creditors, they can trade out of the problems that they've got. And hopefully that will maximise the return that's paid to the creditors of the company. Now, so there's this 21-day moratorium period, and at the end of which, if there's any such proposals, such strategies to enable the company to trade out, the creditors will be asked to come and vote. And that will be passed, for a proposal to be passed, a majority of the value of the creditors and number of the creditors have to vote in favour of it. Secured creditors, if they want to hold on to their security, they're not allowed to vote in the process. And so if it's passed, then that's great. We go to the next stage, and we'll come to that. If it's not passed, there's two options. The receiver can recommend that the company just keep on trading, or more likely, the receiver will find that the company's not able to pay its debts. Usually the administrator will then decide that administrator will then turn into the liquidator of the company, and I'll come to liquidation in a moment. So administration's not necessarily the end of the company, but again, it's not a great sign. And there are procedures in administration that might enable the company to trade on, but they also assist with maximising the return to the secured creditors. Now, if there is some strategy that can be put in place to enable the company to trade on and maximise the return to the secured creditors, that strategy will be put into a document called a Deed of Company Arrangement, and or a DOCA, D-O-C-A. The DOCA will have a deed administrator, and that'll be the administrator, and he will coordinate and manage the implementation of the strategy in the deed, again to maximise that payout or to enable the company to survive, or perhaps both. Of course, sometimes the strategies fail. That's life. But anyway, they give it a fair shot. Moving now quickly on to another form of insolvency administration that we've probably heard of is liquidation. Has anyone heard of liquidation? Yeah. Well, liquidation is really the last stage of a company's life. It's not the only way a company can come to an end, but it's fairly common. The other way is deregistration, but you're not supposed to do that if there's creditors outstanding and owed money. So liquidation is relevant to the insolvency scenario. It's really the last rites for a company, and it's the process of closure. Usually it arises out of the appointment of a liquidator by a court, and that's usually on the application of a creditor after a winding up notice has expired. There are approaches to litigation where the directors of the company can pass resolutions. Sometimes they require support of the creditors if the company is insolvent. Now, the liquidator's task is to identify and sell the assets available and to distribute the proceeds in the manner prescribed by the corporations law. There's a principle called in pari passu. That's a Latin term. I don't know what it means, but it's a Latin term. But I know the effect of it, and that is that all secured creditors should receive the same amount. It should be equally distributed amongst the unsecured creditors. I think I said secured then, but it's the unsecured creditors, those who don't hold mortgages or security against which they can enforce their debt, they should be paid the same dividend. And to enable that to occur, they have to ensure that there's been no preferential payments. That is, that none of the creditors have received more than that dividend than the rest of the unsecured creditors will receive. And that's where these claiming, one of the things the liquidator can claw back is a thing called a preference. A preference is a payment that's made by the company in preference to all the other creditors of the company. So Alan gets 100 cents in a dollar on his $10,000 debt, but somebody else, who have we got here? Eddie gets bugger all, yeah. So he's got a preference. Now I'm the liquidator, I'm going to say, well, that's not in pari passu, is it? That's not very equal. So I'm going to write to Alan and say, Alan, when you were paid, this company was insolvent and it's within 6 months of the commencement of the liquidation or the winding up, and therefore I want to claw back that payment that you've received so that it can go into the general bucket of funds available to the liquidator. And then the liquidator can apply those funds in accordance with the corporation's law. Now, Alan might decide, we'll come and see his lawyer, come and see Gaydon's lawyers. And they'll say, what are my defences? And I'll say, well, Alan, one of the defences is that if at the time you were paid, the company was solvent, that is, it could pay its debts as and when they fell due, that's a defence to a preference payment. Trouble is, it's up to you to prove that. Another defence is that, well, you wouldn't have provided further services to this company if you hadn't been paid, would you? You were being paid the same amount every month for the last 12 months to continue services. That's called a running account. And if that's the case, then that's also a defence, in that your position isn't really any better by getting that $10,000, because you wouldn't, if you didn't get that money, you would have stopped working for the company and provided no more service, and you can show that there was a pattern of progress claim payment, more work, progress claim payment, more work, and that's called a running account. So that's a defence. But it's the big one-off payments that are the problem. And there's also, of course, the problem with payments to associated entities. We've all heard about Phoenix companies, and we're in the construction game here tonight. And we find, Phoenix Pty Limited rising from the ashes with, perhaps the word Australia in brackets in the new company name, or New South Wales or the like. Payments to associated entities, whether they be subsidiaries or companies associated with family members of the officers of the insolvent company, will also be looked at very closely by the liquidator. The liquidator will also look at purchase or sales of assets at less than their market value. They might be uncommercial transactions. Again, that's in effect a preference, really trying to give somebody else a preference over the other creditors of the company in liquidation. So, when the liquidator gets all the dough in the big bucket, and there's a regime like preference of who gets paid first and second, and of course the liquidator's right up there on top. He's the cream in the bucket, of course, because he wouldn't be bothered doing any of this unless he was assured of payment, I suppose, is the argument. So the liquidator gets paid. Also, the costs of appointing the liquidator get paid very early. Next level is the employees and the employee entitlements. So they get paid before your general unsecured creditors. They have preference.
I was more referring to employees being given a preferential payment or a sale of a good that's sold under.
Yeah, well, that could be a problem. Yep. And an employee will probably know that the company's insolvent as well. There's always, we say these things as though there's no costs or expenses to the liquidator in enforcing its rights in this regard. But for a liquidator to commence proceedings against you to recover the $5,000 in addition you pay, it's not going to be worth more than a letter or two to you. If you don't respond or indicate that it's going to cost him, the liquidator, more than it's worth to pursue you, then commercially are you ever going to be pursued? I know you don't want to run your whole life like that, but there's those issues that need to be weighed up in the process, particularly if you've got a couple of one or more sort of semi-arguable defences to a claim by a liquidator. And the liquidators can tend to be very commercial. So it's worth having a close look at the payment that you've received, and perhaps there's good scope to compromise on actions by or threats by liquidators to recover preferential or non-commercial or payments to associated entities. There's been books written on liquidation, law books mostly, and accounting books and the like. It's probably now, of course, the boom area of accountancy law. It's usually an accountant that's a liquidator because it's all about numbers, and it really is a numbers and accounting game, the process of winding up the affairs of a company. At the end of the process, the liquidator makes a report to ASIC and advises whether the liquidator believes there were any payments by, or whether the directors of the company traded on at a time the company was unable to pay its debts as and when they fall due. If that's the case, then the directors of the company are exposed to prosecution by ASIC and are also exposed to more civil claims by people who have incurred a loss as a result of the company trading at a time it was unable to pay its debts as and when they fell due. So if you, I suppose the takeout of that is that if you're a director of the company and you think you have issues about your ability to pay the debts that are being incurred by the company, go and see an insolvency advisor or a lawyer to work out whether you're just, all you're doing is digging a deeper and deeper hole for yourself. You don't want to lose your home as a result of trying to trade out in really difficult circumstances. Often in liquidations we find, it's probably 60 or 55, maybe 65% of liquidations where by the time the liquidator gets appointed and by the time he looks at the affairs of the company, there's no assets really to take it any further. There's no pot of gold there that's available, so the thing gets wound up pretty quickly. Liquidators, they win some and they lose some. Quite often there's not enough assets to pay the liquidator's fees in the liquidation itself. If there's no money in the company, there's no government fund to fund liquidators' speculative actions against creditors or to pursue the debts. So again, it's a very commercial game. But if there's no money in it, it's unlikely that the liquidator is going to bother taking it very far. So that's the four main forms of insolvency administration. Perhaps now I should turn to some contract forms. I apologise if the contract forms are not the types that you're used to, and hopefully I won't make you glaze over too badly, but I'll try to power through it anyway.
Just before you go on.
Yes?
Say, for example, you said there's not enough money for the liquidator to pursue it. But what happens to the directors? Is there a record taken? Are they negligent?
If the liquidator is...
Continue to trade, can they get another company?
Yeah, there's... just because your company goes into liquidation, that doesn't disqualify you from starting another company or continuing to be a director in another company.
Isn't there 3 years?
You'd have to be prosecuted by ASIC for that type of outcome. There's no 3-year prohibition on managing or being involved in the management or directorship or being a company officer.
So you can
Nothing at all like that.
liquidate today and everything is settled.
Yep.
And you can go and start up another company.
It's called the corporate veil,
Okay.
which is the separation between the personal affairs of the director and the company. There are avenues, if you do get prosecuted by ASIC for breaching the law in relation to the management of companies, whether it be for uncommercial transactions or trying to hide money from the creditors of the company, then you can have those type of outcomes that people are banned from being a director of a company, a la Rodney Adler. You can also end up in Goulburn Jail as well. But I mean, what sort of percentage of company directors end up in jail? If insolvent companies, it'd have to be 0.0001%, wouldn't it? It's pretty rare.
But a builder would get his licence refused, though, or revoked.
No, the builder won't. If it's a company insolvency, if the builder's bankrupt, then you won't be able to get home warranty insurance for a start. But yeah, that will have an implication upon your ability to get a licence. But the company can go insolvent, and the builder keeps, the responsible officer keeps his licence. Yeah, that has no implications. The company going into administration or going into liquidation, I suppose the question arises, can that company continue to undertake building work? Well, a liquidator might think that it's worthwhile completing a contract. They wouldn't get too involved in it. That is, it'd have to be very near completion, and we're only doing some minor tweaking to get the thing over the line and get that final claim paid, or to get it to practical completion, so that a claim can be made and the sale of the asset can be completed and the like. There are the Director General of Fair Trading is able to give consent to an administrator to complete residential building work. I don't know how you get the Director General of Fair Trading to consider anything at all quickly, unless you get it in the Daily Telegraph, of course. Then they'll think about it quickly. But yeah, we, like most commercial people, have a lot of difficulty getting politicians to consider commercial issues if it doesn't involve protection of a marginal seat or the spin that they're trying to create at that time. Then there's an issue as to whether it's practical to expect that you can trade on with residential building work anyway. And that's because of the strict requirements in the Home Building Act, which you probably come across from time to time. Certainly keeps a few of us busy. Now, in terms of standard form contracts, the Australian Standard Suite is the version of contract that I use the most in my business, and that's because my clients like it, they come to me with it, we recommend it for them for projects. It's not something that you probably use for anything under about $1 million worth of work, however. But anyway, so it is the most common or possibly best known contract form for developers anyway. Now that's interesting because if a company goes into one of these insolvency administrations I've been talking about, under the Australian Standard Suite, the default position is that all you're entitled to do is take the work out of the hands of the contractor. You've then got to give that work to another contractor, and they've got to complete the work, and then at the end of the day accounts are taken and we work out who owes who. Now, if your insolvent builder owes you a lot of money, well, it's probably not worth much to you really, because you're only going to get a few cents in the dollar, potentially, if anything. Maybe you'll get more, who knows, you might get lucky. Chances are by the time all of the insolvency practitioners and the like have had their go at the proceeds of the company, there may not be a lot left. On the other hand, if you complete that work more cheaply than your insolvent builder, guess what? You owe a debt to the liquidator. You've saved money as a result of your contractor's. And you might laugh, but I've seen it happen. I've had a client who actually managed once the builder got insolvent and was off the site, and a new builder was appointed. They complete the apartments and they saved money as a result. Now the Australian standard form contract says that saving has to be paid over to the company that was insolvent, which means to the insolvency. So that's interesting in the Australian Standard. I recommend that you change that in that contract form, that it's an amendment that might be worthwhile making. The The other form that we use a lot is called the Australian Building Industry Contract, which is MW1, and it's got a sister contract called SW1, which is on a bit of a smaller scale. Now, that's a contract that's issued from the MBA and the Royal Australian Institute of Architects. Now, an issue arises in insolvency that you want to protect if you can. If you're a developer, you want to potentially protect the contracts with the subcontractors for the various trades. And the reason you want to do that is that potentially those contracts might have been let 18 months ago, and they were let by hopefully a contractor who was pretty good at negotiating the contract terms. And so it's probably worthwhile trying to negotiate with those same subcontractors who are potentially mobilised on the site, familiar with the site and the like. Now, the MW1 and SW1 forms require the builder to assign its subcontractors to the principal in the event of contractor insolvency, which is it's good in theory to get that there. As long as the builder can effect that assignment, they've got to use their best to do it. Both the Australian standard form of contract and that MW1 don't require any more further payments under the contract once the contractor is insolvent. You've got to wait until the works are complete and the dust settles, and then accounts are taken and you work out. So we've got to get the job all the way to practical completion, maybe even final certificate, and work out who owes who the money. But your regular progress payment regime comes to an end. MW1 is helpful in that it specifically provides that in the event of contractor insolvency, the principal is entitled to take possession of documents, plant and equipment on the site and to use them for the completion of the works. There is a provision in the Australian standard along those lines. It's not as good as the one in the MW1. Now, the Housing Industry Association's residential building contract for new dwellings, which perhaps you're more familiar with, it really doesn't address the implications of builder insolvency. Doesn't say much at all about it. I think it just leaves it to an assumption that if the builder's insolvent, the builder's going to fall in default of the contract. The builder's not going to be able to fulfil its obligations under the contract. So eventually the homeowner is going to serve a notice, the 25-day notice under that contract, and eventually, because the builder is insolvent, the liquidator won't be interested, or the administrator won't be interested in remedying the default, and it'll give the homeowner an opportunity to terminate, and that'll bring it to an end. BC4 states that if a builder is in default, that's the Master Builders Association, BC4, the builder will be in default if the builder commits an act of bankruptcy, executes a deed of assignment, and goes through all these various modes of insolvency. But again, it doesn't say much about what happens. It says that the builder is in default, you can give notice, and then you can terminate the contract, but there's not much in it in terms of what happens to specifically cater for the insolvency event. Neither the BC4 or the HIA residential building contract address the suspension of payment for money due under the contract, or they also don't deal with the direct payment to subcontractors or any entitlement to set off payments to contractors by the homeowner against monies claimed by the insolvent builder, which is a shame. It can be useful. Often, to get subcontractors back on site when the builder's gone belly up, the subcontractors are often going to want to be paid money that they're owed by that builder, aren't they? That's what we find, and you usually end up members of the CFMEU knocking on the door, and they want to know what you're going to do about all our unpaid members, don't they? Usually it's going to be to your advantage, I think, to make some form of accommodation for them if you're a principal. It's just easy to get the same people back on the site, particularly if the prices for that work are fixed. particularly if they're really essential subcontractors. I mean, some of them you might let go, but you know, if you've got a substantial electrical contractor who's well into the work, carpenters and the like, well, there's all sorts of problems can arise. In terms of site issues on head contractor insolvency, well, of course, the contractor was appointed as principal contractor for the site, and he's going to be responsible for the safety, security and insurances. And now those matters with contractor insolvency are highly likely to be neglected. Questions will immediately arise as to who owns the temporary fencing, who owns the scaffolding, who owns the haulage, hoistage and the like. Suppliers of that type of hired equipment will be insisting on payment, and quite likely they'll come around and remove their equipment if you don't pay, although some of the temporary fencing guys are pretty slow to do that. It's pretty good. They do cooperate. I've been impressed by some temporary fencing companies. You might have different experiences, but they don't come along and take it away. They must, maybe they've got some agreement with work cover as to what they're going to... Do they? We've had some interesting stoushes with scaffolding companies about scaffolding. You know, they want to come away and take it away, but they also want to charge you $15,000 for coming and taking it away. You go, no. You want to come and take your stuff, come and get it. And then they send in the heavies. Of course, a building site without temporary fencing breaches all sorts of conditions, not only of work cover and the like, but there's also development consent conditions and laws in respect of occupational health and safety. It's going to also breach covenants in loan agreements if the site's going to be run like that, so there's all sorts of problems. That fencing issue is something that needs to be dealt with very quickly. And of course it also, if they remove the temporary fencing, you'll suddenly find things missing from the sites, and garage door motors have been removed and fixtures and fittings have gone, and where's the kitchen sinks and the like. So maintaining site security and fencing and the like is very high priority. I'm not sure whether the appointment of if a company goes into liquidation, its insurance policies are still going to remain on foot. Mr. Nadu? Until they expire, until the term expires, it shouldn't affect the coverage. Is the company the company's still in existence until it's deregistered by the liquidator. He goes through that liquidation process, and at the end of the day, he says, "Right, Mr. Asic, I've finished." Yeah. Yeah. So that's the works. Well, what do they call it? Yeah. So that policy is still in existence. Good idea to check what the arrangements are, though, because often, in the dying gasps of company, they can let insurance policies and the like go because they haven't got the money to fund the renewal of the policy. So it's always a good idea to check. And I'd recommend clients, if you know who the broker is, give them a call, find out what the position is. Brokers don't seem to mind about talking about these. Particularly if you're going to be noted on the policy, you're entitled to know if it hasn't been renewed. There's home warranty insurance, of course, and I shouldn't at this venue be deprecating that fine form of insurance, should I? Bill's not here. Well, that if the builder goes insolvent, the homeowner probably has a remedy, but any developer won't, because if there's 4 or more dwellings in a development, the developer is not a beneficiary under the home warranty insurance policy. So it may or may not provide some comfort for a homeowner. Certainly doesn't provide any comfort for builders. In fact, quite a bit of discomfort from what I hear. So we're talking about subcontractors. From a developer's perspective, when the head contractor becomes insolvent, preserving the existing subcontracts is a pretty good idea. And that's because of the likelihood or possibility of maintaining those prices that were established some time ago. Subcontractor, well, they'll simply want payment for what they've been paid, for what they've done, and the materials, of course, that they've provided at the site. And the subcontractor's possibly not going to be terribly particular about who pays the debt. Doesn't care whether the insolvent builder pays it or whether the developer of the property pays it. Or they just want to be paid. They've got their own bills to pay. Subcontractors are probably unsecured creditors. General unsecured creditors, that's the bottom rung of that priority of payments, with the cream on top being the insolvency practitioner, and then the sort of mid-level being the employees, which is often a substantial chunk, the employees of it, and then the lower echelons who are either not going to be paid anything or they just get paid a dividend, which is cents in the dollar. Yeah, sometimes there's not much for the employees either. So if you're a developer, and I know this is not a developer's venue, but developers will seriously think about purchasing the subcontractor's debt. So if you're faced as a subcontractor with a head contractor who's gone insolvent, you should approach, I suggest, the developer and see whether they want to buy the debt that's owed to you by by your entitlements against the owner. And if they do, they might be able to set that cost of buying the debt off against what they already owe the head contractor, what they haven't paid under recent progress claims. That will probably involve a thing called a deed of assignment of debt, where the debt that's owed to the subcontractor by the head contractor now becomes owed by the developer. Good thing for the subcontractor is that when they sign that debt, they get a Gregory Peck, they get a cheque. Usually the developer will require the subcontractor to release all other claims that they might potentially have in relation to the property or the works that are performed by them as well. That's probably reasonable, given that if the developer didn't step in to pay the subcontractor would be out of pocket entirely. So all that's pretty technical in theory, but it's worth approaching that developer, and don't the unions know it? They're straight in there to do it. But there is real value for the developer. Now, finally, there's a few things that can be done to building contracts to better respond to contract insolvency. And the good news is the last thing I want to talk about tonight. So you're a good deal closer to a schnitzel and a beer. Ensure that you claim frequently under your contracts, under your subcontracts or head contracts or whatever. And if you don't get paid, you've got to exercise those suspension rights. Don't be too exposed. It's a high-risk strategy. If you are going to get exposed, you really need to have protected yourself by having some form of security in place. Sufficient security to cover what you're owed. But of course, that Security of Payment Act, if you've served a payment claim under the Security of Payment Act and you're entitled to a payment and you don't get paid and there's no payment schedule, or they've promised to pay you a certain amount and they don't pay it, then you give a couple of days' notice in the correct form, which is pretty simple, and then you're entitled to suspend the works, and they can't sue you for the losses that the head contractor or the developer incur as a result of your suspension of the works. You're protected. May not be great from a relationship point of view with the head contractor, but that's a commercial decision that you need to make. That's not a legal one, it's a more financial one, isn't it? Relationship thing. I've seen it done a lot, and it hasn't, I can't think of a single instance where suspending the work when the subcontractor is entitled to do it. I can't think of a single instance where that has been the cause of the severance of the business relationship. It's an entitlement. Building contracts, if you were a developer, you might want to think about making sure that the contract entitles you, the developer, to pay your subcontractors directly if the head contractor goes insolvent, and entitle you to offset those direct payments to your subcontractors against any money that's claimed by the head contractor or the head contractor's liquidator. That entitlement doesn't come naturally. There are some insolvency law reasons why you may not be entitled to set off payments that you make directly to the subcontractors against money that you owe the head contractor. Really, to be sure that you can do it, it needs to be in the form of contract, written contract that you use. As a developer, of course, they need to avoid front-loaded payment regimes, because if the contractor goes insolvent, there may not be enough left in the contract to complete the works. If you're a subcontractor, it's probably the other way around. You want to pursue front-loaded payment regimes, because then the impact upon you is going to be less. There's a thing called a deed of election that can be included in a building contract, and it involves, the scenario is this, that the clause provides that if the head contractor goes insolvent or breaches the contract and the contract is terminated, the developer or the property owner or the homeowner can can step into the subcontracts. Now, it's got to be a requirement in the head contract. It's got to say every subcontract you enter into has to contain a provision that you will, in the event of builder insolvency, you will permit the developer to step into the contract that I have with you, sort of novate it or assign the contract to the developer or the homeowner. Some contracts there are contracts that require, well, most contracts these days, that at the time for progress payments, the head contractor has to provide a statutory declaration saying that all of the subcontractors have been paid. What's being required these days is not only that statutory declaration has to be provided, but the head contractor has to also procure similar statutory declarations from each of the subcontractors for each of the main trades, and also provide them to the developer at the time of the progress claim. Now, that's quite useful for the developer or the or the owner, for the reason that if the contractor goes insolvent and the union turns up and says, "We act for the electricians, we haven't been paid for 5 months," well, the owner or the developer can pull out the statutory declaration and say, "Well, why the hell does this, your subcontract, why the hell does your member complete these false statutory declarations saying they've been paid up to date?" It's quite a powerful weapon in terms of answering claims. If what the union member is saying is correct, that is, if the subcontractor is owed money, then they're of course involved with a breach in a breach of the Oaths Act, just like Justice Einfeld. Don't think they'll get on 4 corners though. So yeah, they will have broken the law, so that's perhaps something that will assist in negotiations with the union heavies. So that statutory declaration requirement is also good because it gives some assurance to the developer that those progress payments that have been made to the head contractor are actually going to the people that they're supposed to be go to, that the lifeblood of the work is actually getting out to the extremities, being the money, as they say in the Security of Payment Act. Now, that completes the presentation for this evening. I'm sorry it got more and more technical as we go along. I hope I didn't go overboard on that. But if there's any questions, yes?
Yes, in terms of frequent payments, organising frequent payments.
Yes.
Now, the lender has stipulated 4 payments only, and the contract is well over $1 million. and then they send the quantity surveyor, whoever it is, well, you've claimed 300,000. They say, oh, no, Mr. Talevsky, we can only pay you 180. Now, you're truly financing this project indirectly. What, can you claim the interest?
Well,
or can you
you're-
force extra payments?
You're working under a contract with your customer. You're not working under a contract with the financier. The customer has to go and make arrangements that can satisfy their obligations under the contract. If your customer hasn't gone and done that, then they're going to be under default in the contract, under the building contract, because they can't meet their payment
the money
obligations.
is lent strictly on on their particular payment schedule, and they won't alter. I got caught on that.
No, it happens all the time. I know there's a mismatch between what the bank, the facility that has been put in place between the bank and the owner, and the payment obligations under the contract and perhaps the Security of Payment Act. And we see it all the time. But it means that the homeowner or the owner of commercial property has to put their hand in their own pocket, or they have to go to their bank and alter or vary their obligations so that they match. Now, the owner is going to be reluctant to do that, and the bank is probably not going to be terribly helpful at all. And as a contractor or a builder, you've got to make up your mind whether it's worth your while pursuing it or not. But of course, you can should be able to suspend work for non-payment if that's what occurred, and your entitlement to do that, if it's under the Security of Payment Act, there's provisions in there that they can't claim any losses that they incur as a result. And your contract probably provide that as well, but there's no substitute to reading the contract before you take that type of action. Does that answer your question?
Not entirely, no. Because I was really, I was in a hopeless situation. I just couldn't do anything. I couldn't suspend the work. I would be causing delays, and there could be charges. I sort of dug my heels in. I said, well, I want to be paid. They said, well, take a walk. Now, I've put X amount of money in this contract, in the building.
So you're a stakeholder as well, really. You need to get to completion. Yeah.
And now, the further you go, the deeper you get into it.
That's right. Yeah, that hole's been dug
and
deeper and deeper.
And I had to go and borrow money and really get a second mortgage on the house.
Unless there was a tripartite agreement between the bank and...
Well, even that doesn't help. That usually only serves to benefit the bank rather than the builder. Tripartite agreements. You know, they involve things like the builder has to give the bank notice before it terminates. They involve things like a step-in right, that the bank can step in to the principal's shoes to complete the contract. But what it won't say is the bank is going to, or the builder has any rights against the bank. You don't see that in tripartite agreements. Yeah. So there is a bit of a contract there. But is it residential work? Or, yeah, are they living in the premises?
Oh, not yet. Well, yeah, they completed.
They intend to, yeah. Yeah, so you see the Security Payment Act may not apply to it by the sounds of it. But your contract for non-payment should entitle you to suspend, but that's still not necessarily the best outcome.
Well, you couldn't, yeah.
No, you want to get that work finished and you want to move on to the next job, don't you?
It's this thing called money.
Yeah. Bloody thing.
Just to add to that a little further, I've come across the same situation twice, and it sounds to me like one thing's happened is firstly, you might have entered the contract a little early or gone too far into it before the bank's committed to lending the money in relations to the contract that's been signed. But on just to add, on 2 occasions, I myself, acting on behalf of another builder, have gone to the bank directly and convinced them to go not from a 4 payment schedule, but for 6 individual payments to be changed into 26 payments.
Yeah.
And on both occasions, with 2 separate banks, have gone for it both times.
Cash flow. What the bank will be mostly concerned about is that there's enough in the finance to complete the work.
Yeah, they don't want top heavy like you were saying earlier. But on both initial occasions, were just basically they've got percentages to lock up and etc., which can restrict your building process.
Both the Housing Industry Association's contract and the BC4 entitled or require the homeowner to prove to the builder that they've got sufficient funds and arrangements in place to pay for the work. I know the BC4 also entitles the builder to refresh that information when they request, give a written notice to the homeowner to do that. So there are ways to get some assurances about the homeowner's ability to pay during the works. But that suspension right is pretty powerful, but it's not necessarily going to resolve the issue. One would hope that the homeowners have made enough financial arrangement for completion of the work. Trouble with variations and things change. Have they got the financial facility amended and the resources in place to actually pay for them? And I mean, what if there's during the conduct of the work events that occur that entitle the builder to delay damages and extra expenses that they would not have been budgeted at the time the homeowner entered into the contract or at the time they entered into their finance facility? So, yeah, that could be a problem.
In terms of liquidation, in most cases, you find that the last progress payment or the progress payment prior to the builder going into liquidation is generally held back by the owner.
Generally, yeah, they've got a sniff of it. Yeah.
And looking at a commercial contract, how does the liquidator handle that aspect in terms of the security of payment?
Yeah, often there's not a lot of money in the contract itself for a liquidator. You'll find that attempts to recover unpaid progress claims are met with claims to the effect that the builder has already been overpaid. Payments that have been made to date were payments for instalment payments on account, and that the builder was overpaid and there's still 20% of the work to go when they've been paid for 90%. And that is common. Also, attempts to offset claims for defects and the like. Yeah, it's not a simple thing. It's a hard row to hoe for a liquidator to recover that. Sometimes it's clear cut. Often it's not, particularly with larger projects. It's not. Yeah.
Final question. Does anybody need answers to the assessment form while it's still standing up? No? All right. Robert, thanks very much yet again. Very interesting topic.
Pleasure.
Much appreciated.
Thank you.
Thank you. And
thank you very much. Very kind.
Thank you, gentlemen.
Thank you.
All right, that's it till our June meeting. Speaker and topic not as yet decided, but I'm sure it'll be interesting, and we'll look forward to seeing you then. Thank you. Good night.
There you go.